this morning's docket. That is case number 109915, State v. Pribble.
May it please the court, Peter Meharry for Jeffrey Pribble. If I could reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
Thank you. In this case, Mr. Pribble was convicted of various drug offenses and he was ultimately sentenced to 42 months incarceration. It comes before this court on a petition. Mr. Pribble did appeal to the Court of Appeals. He raised 3 issues in his brief and the Court of Appeals ultimately affirmed the conviction and sentence. As I said, we've raised 3 issues in the brief with the Court of Appeals. We've raised those same 3 issues in our petition. And I'd like to start with the second issue, which is the prosecutorial misconduct issue. In this case, we have asserted that there were several improper comments made during closing arguments by the state. The Court of Appeals agreed with us in part that there were improper comments, but at the end of the day, it did find that those comments were harmless. Starting with kind of just running through the 3 groups of categories of comments, we believe that the state improperly misstated the law during closing arguments. The state used an analogy as to what was required for possession. In closing argument, the state said, if I was to walk into your home and find a remote control on a couch, well, maybe Alex Martinez was over there and dropped off the remote control, or maybe there was some big party, but it's still yours. It is our contention that that is a misstatement of the law as to what is required legally for possession, and the Court of Appeals agreed with us on that. It went on to get, as I said before, to find that that was harmless, and I'll get to that in a little bit. The second category of comments, we believe the state improperly vouched for witnesses and commented on the credibility of my client's testimony. In closing arguments, the state said, I don't believe that's credible, referring to my client's testimony, and I don't believe you ladies and gentlemen should believe that's credible either. Went on to say, I don't think those things add up because we know that the officers didn't make him put on that shirt. We know the officers didn't tell him it had smallpox. Again, the Court of Appeals found that this was an improper comment because it was the prosecutor interjecting his own personal opinions as to the credibility of the witnesses. Again, the Court of Appeals did find that that was harmless. The final comment we believe was improper is comments we believe improperly shifted the burden to the defendant. In rebuttal closing arguments, the state said, well, ladies and gentlemen, the defense has the exact same ability to subpoena witnesses, and if he was at Fall River, his sister could have told us, his nephew could have told us there was a big party, Terry Moore could have come in and said none of this stuff was there when I left the house, Alex Martinez could have come in and said, yeah, I was at the house, and guess who we heard from? No one.
That last comment was in rebuttal, wasn't it? And wasn't it in response to defense counsel stating where's the evidence, where's the DNA, where's this, where's that, and wasn't that in response to that observation by your client?
There was a comment by defense counsel in closing arguments that we did not hear from those witnesses.
Right.
And defense arguments in closing arguments was that essentially that the state did not do its job, that we didn't hear this type of evidence or they didn't get this type of evidence. But I think the problem I have is that this doesn't say we presented our case and we had the evidence sufficient to show our case and prove our case. I think this goes that one step further and says the defendant didn't call these witnesses. The defendant could have, but didn't. And I think you're implying the defendant has an obligation to do so at that point. And I think that's where it crosses the line and shifts the burden to the defendant.
Is it implying that there's an obligation to call the witnesses, or is it just an observation that you could have called the witnesses?
I read it as implying that they should have called the witnesses, that they should have presented this testimony if the defense wanted to fully present its case. And the defense doesn't have that obligation. So I think it goes kind of one step further than just responding to a defense counsel argument. it goes that one step further and puts a burden of proof or burden of production on the defendant. And I think that's where the Court of Appeals, they found that that was not an improper comment because it was in rebuttal. And I think they misread or minimize the fact that I think it goes that one step further and puts a burden on the defendant.
Is that a distinction between this case and those cases cited by the Court of Appeals in support of their position? I mean, is that the same situation that occurred in those cases?
The way I read this one is it goes further than those other cases. There are cases out there that says you can respond and say, if the defense gets up there and says this person wasn't called, the state can respond and say they have the ability to call a witness. But when I read these statements, I think it goes beyond that, as implying that not only can they, but they should call those witnesses to establish their defense and establish their case and to disprove the state's case.
Is there any specific language you point to for that position?
I don't point to any specific language. It's just comments as a whole in the closing arguments.
More the tone of the statement.
And what the state is going after in their rebuttal closing arguments. I think their implication again was that the defense didn't do this, and they needed to. And we all know the defense doesn't have to do that. So I think in that regard, the Court of Appeals was incorrect in finding that that was a proper statement.
Was there any distinction in the argument that was being rebutted? In other words, what the defense had indicated? Because I see a difference between saying the state didn't meet its burden of proof and saying and intimating that the state is trying to hide something by not calling a witness. And was there any distinction between the comment here and those in prior cases that have allowed a similar statement?
The comment that the Court of Appeals points to as to what this was in rebuttal to was, we didn't hear from Terry, we didn't hear from Alex, we don't know their side of the story. And I think the state's comments, saying that they have the ability to subpoena those witnesses, but then they go on to say, and we didn't hear from anybody. I don't think the defense was saying the state was trying to hide anything. I think the defense was saying the state didn't prove its case. The state didn't do these certain things, including calling these witnesses. But when the state gets back up there and says, well, they could have called these witnesses, I think that is saying they should have. That's implying that they should have. So I don't think that the comments that they were purportedly in rebuttal to implied that there was some type of cover-up or the state was trying to hide something.
What is wrong with if the defendant says, we didn't hear from a witness, and the prosecutor said, well, we could have heard from the witness if the defendant wanted you to hear from the witness?
I think when you look at the bulk of the comments here, I think they go beyond just saying, the defendant said we didn't hear from a witness, they could have called him. I think the implication, what they say here, is that they should have called him. The defense needed to call them. If they wanted to get this testimony, that's their obligation, and their obligation to prove this essentially defense. And I think that crosses a line and just goes beyond just saying the defense can call these witnesses.
See, that's what he says. The defense has the exact same ability to subpoena witnesses. And then he goes on to say what those witnesses could or could not have said. That's not saying he should have called them. He said they have the same ability to call as we do. Isn't that accurate?
That's not how that's not how I read it, Your Honor. I read it as implying, they needed to do this. It's their obligation to do that. So I think that's where we believe it does cross the line into shifting the burden to the defendant. As I said, the Court of Appeals did find several of the comments improper, but at the end of the day, they did find it was harmless. The Court of Appeals did not find any ill will. They did not find that the comments were gross and flagrant. And it also found at the end of the day, the evidence was overwhelming such that these improper comments that it found would not have an impact on the verdict or the jury. I think the Court of Appeals should have found gross and flagrant misconduct here. Just taking the two comments, kind of two groups of comments, the Court of Appeals itself found was improper. Misstating the law and commenting on the credibility of witnesses is well established that that is improper conduct. Those have been set out by this court for years. Certainly no secret, and the prosecutor in this case should have known that. The other thing the Court of Appeals noted was that every time there was an improper comment, the prosecutor did either quote the instruction or state whatever correctly. For example, with the analogy where he misstated the law, the prosecutor also quoted the instruction on possession. And the Court of Appeals said that that kind of shows that there's no ill will, that it's not gross and flagrant. I guess I see it the other way in that the proper statement of the law is there in front of the prosecutor and he is reading it. And he should then know better than make the analogy that he did. Similarly, the prosecutor quoted the part about credibility is left for the jury. But then at the same closing arguments, he gives his personal opinion on the credibility. I think that shows a disregard for the instructions that the district court gave and what is well-established law. So I think there is gross and flagrant misconduct in this case and ill will.
Does ill will have to be intentional?
I would say no. I think it could kind of be kind of almost reckless, just kind of disregarding what has been, if there's a court order, the prosecutor kind of gets away and goes off on a tangent, not necessarily with the idea to violate the court order, but he ends up doing so. If he does it multiple times, even if maybe there wasn't a grand scheme or grand intent to do so, I think that can be ill will on the part of the prosecutor.
So in this case, was it intentional from your view of the record?
From my view of the record, when the prosecutor states on the record the standards, when he quotes the jury instructions, which are accurate, and then gives a statement as to what possession is, which is wrong, and then comments on the credibility of witnesses, that to me is ill will. That seems intentional on the part of the prosecutor to disregard those instructions, disregard the well-established rules of this court. It's hard, when I read the closing arguments, he starts out his argument quoting the instruction on possession. What is required to prove possession in this case, which has knowledge and intent required. It's essential. And then he talks about, if you have a remote in your house, that's possession. It's hard when it's basically a few paragraphs later for me to believe that he didn't know what the standard was and made that analogy to lessen the load on the state. That seems to be intentional to me. I certainly wasn't there, but like I said, he had the correct standards right in front of him. He was quoting from them, but then he goes on to disregard them. So I see that as an ill will on the part of the prosecutor. I see it as gross and flagrant misconduct.
So what was his purpose in quoting from the jury instructions?
I don't know what his purpose would be, presumably to correctly state the law for the jury. But then he goes on to essentially disregard that in this very same closing arguments. So I don't know if he had an overall grand scheme or not, I don't know. I certainly would hope or believe that it was to present the case and the proper standards to the jury. But then, as I said before, he goes on to disregard those standards.
He basically misstated how the jury was to apply the law, didn't he? When he gave the analogy, he was giving an analogy of how the law applies to facts.
His analogy certainly is drawn from the facts of this case. That is correct, Your Honor, because in this case, the question wasn't whether or not there were drugs in the house. There were drugs in the house. The question of whether or not my client knew about it. And the analogy was certainly drawn to what the state had to show to establish possession.
And this was in the opening portion.
I believe that's correct, Your Honor. I think
And one would expect that the opening portion of a closing argument would be prepared ahead of time.
I would assume that they have more of a script for the opening, and rebuttal is obviously more in response. I don't know if that's the case with this prosecutor or not, but that, generally speaking, sounds right. The only part of I believe the statements we believe are improper that were in rebuttal were the shifting of the burden, and then also we raised some issues with prosecutor talked about not following these red herrings, or language to that effect. But the remaining parts were in the opening part of the closing arguments. Final question, I'll just briefly wrap this up as I see I'm out of time, is whether or not there was overwhelming evidence such that this doesn't impact the jury. The Court of Appeals found overwhelming evidence, but I think they looked at it the wrong way. As I said before, the question here is not whether or not there were drugs in the house. They found a lot of drugs in the house. The question is whether or not my client knew about them and whether or not he had the requisite intent to be guilty of possession. And when you look at the improper comments here, particularly when it was the state misstating the standard for possession, it is lowering the standard. And if you only require that they be in your house, nothing else, which is what the analogy goes to, then regardless of what my client said, my client would be guilty. So these do impact how the jury would have viewed the evidence in our view, that the state is lowering its standard of proof, its burden of proof to establish possession. And at the same time, they are undercutting my client's credibility by commenting on his credibility in closing arguments.
The prosecutor could have appropriately said that the quantity and pervasiveness and widespread nature of the drugs in the house was circumstantial evidence that your client had the knowledge and intent required to have committed the crime, couldn't he?
I think you can make that argument, Your Honor, and I think the prosecutor did.
Well, that's what I'm saying. Isn't what he said in essence? I mean, when you get down to it, what it suggests about mere presence sealing the deal is wrong. But the mere presence of all of that drug evidence in the house owned by your client was circumstantial evidence of knowledge and intent.
All of that was there. That is an argument, but I don't think that's what, when he's using his analogy, is his argument. Because his analogy is just talking about a remote control. He's not talking about you walk into your house and there's 50 dogs. Probably have some knowledge and intent can be inferred from that because there's so many dogs. But when he talks about if I was to walk into your home and find a remote control on a couch.
Right, but the remote control wasn't at issue here. What was at issue here was an abundance of drug evidence, right?
Correct.
So the fact that he talked about a smaller amount of something else, by way of analogy, doesn't defeat the fact that there was an abundance of drug evidence in the house, does it?
It doesn't
So
change.
it was a
the fact.
bad analogy. He was wrong to the extent he suggested that the mere presence means that you are unequivocally guilty. But it wouldn't be wrong to say an abundance of drug evidence is pretty good circumstantial evidence that you couldn't have missed it as the owner of the house.
And we aren't contending that that argument is improper. We're contending that this analogy, where he talks about just your presence alone, you're liable for every little thing in your house. That's the problem.
But the every little thing wasn't what the case was about. What the case was about was a lot of evidence, right?
There was a lot of drugs in his house. That's conceded. But at the same token, the jury gets back there and they say, prosecutor said he's liable for things in his house. At the end of the day, I don't think that's the correct standard, and I think it did affect the jury's verdict in this case such that we believe a new trial is warranted.
Thank you.
I'd like to move you to the multiplicity argument and then to the unit of prosecution prong of that
Okay.
analysis. Why should we not see 2 units of prosecution when the legislature has defined the amount of tax that you pay for marijuana and the quantity that you have to possess of marijuana different than they have for a controlled substance?
I guess kind of two-part response to that. Number one is this court has set out kind of a framework to look at this. And the first question is whether or not there's unitary conduct. And when you look at the factors involved there, same time, same place, was there a fresh impulse? I don't believe so. Was there an intervening act? I don't believe so. So I think we have unitary conduct, and then you get to the unit of prosecution. And that's how has the legislature defined the scope of the conduct that will comprise one violation of the statute. And in the statute, it talks about stamps and labels in the plural tense. And failing to have your stamps plural, labels plural, is a violation of the statute. And our reading of the statute is that it's not every single drug needs its stamp, and therefore you have a violation for every single drug without a stamp. It's, you look in the aggregate that you don't have your stamps for all of your drugs. By using the terms in their plural tense in the statute, and equating that in the statute to a conviction under the statute, we believe that the legislature is saying is, we look in the kind of more of a global sense. Did he have his drug stamps for his drugs? And if he didn't, that's one conviction.
So the answer to my question, I take it, is that the fact that the units of the amount that you have to possess and the amount of tax you pay is irrelevant to a consideration of the unit of prosecution?
I think it is. I think that is actually more relevant to how much you pay. My understanding of the statute, it's a little bit dependent on the weight. And if you have so much of marijuana or so much of other controlled substance, you pay X amount. So I don't think that plays into whether or not there is a unit of prosecution here. And I go back to the statute, which does use, talks about stamps and labels and indicia in the plural sense. Statute, we believe, equates that to one conviction.
Doesn't the statute show there's a unit of the stamp. The stamp costs so much money. You'd have to use, depending on the amount of controlled substance or marijuana that was possessed, it would include more than one stamp. Is that not correct?
That's my understanding, is that, the stamp is based upon weight.
Right.
So however much as far as drugs you have is depending on how many stamps you would need.
Right.
But the point is they're predetermined. So
Yeah.
you don't order, if you have 1.65 ounces or whatever, you don't order a 1.65 ounce stamp. You order stamps in a denomination. And that's what Judge Malone's saying, is if you have 1.65, you're going to have to probably round it up, and you're going to have to order however many stamps will cover you for that, which would mean the legislature anticipated that when it used the plural of stamps. Even though it's a one transaction with marijuana, that's still going to involve multiple stamps. So I don't see where that use of the plural carries the day for legislative intent that marijuana is part of the same unit of prosecution as other controlled substances.
Well, I guess I agree. I think, you buy these stamps, you get as many stamps as you need based on how much drugs you have. And I think by saying stamps in the statute, the failure to have your stamps is a conviction. And I don't think it matters if you have multiple drugs. I think the only thing that matters is, do you have stamps?
That's a great argument with regard to controlled substances. like meth or cocaine, because there's only one definition of controlled substances, there's only one amount that triggers tax, all of that. So they have grouped all controlled substances together, but made a separate provision for marijuana. And what is the legislative intent of separating those if it's not to create different units of prosecution?
I think the legislative intent is just because of the differences you're going to have in weights. It can't group marijuana with other controlled substance because you're going to have so much more marijuana than other drugs. When you look at, and I looked at the statute, but I don't have it in front of me, the amount as far as weight of marijuana requiring a stamp or what have you is far larger than the other controlled substance. They were able to group those controlled substances because in those drugs, you're more or less dealing with kind of the same levels of quantity. Marijuana, you have far more. So I don't think the distinction between the two is because they want multiple prosecutions here. I think it's just because at the end of the day, marijuana comes in bigger packages. So I think it goes back to the statute still is using the plural to define a conviction.
So you think the legislature was trying to impose a fair tax? Is that what you're saying?
As far as the legislative intent on the statute, I don't know. I have my theories on why they imposed this, but it's more conspiracy theories than anything else. But I think they recognize at the end of the day, marijuana, you're dealing with different quantities, far greater quantities than the other drugs. And that's why they set it out the way they did, not because they wanted multiple prosecutions for each individual drug.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. I will start with the misconduct claims as well. It's our position that there is no misconduct here during the prosecutor's argument, and we would ask that you do not divorce these statements from the entirety of the argument. Please focus on them in context and look at them in that way. And beginning with the first claim that the prosecutor misstated the law, I think Justice Beyer hit the nail on the head when you mentioned that he was speaking about the pervasiveness and the quantity of the drugs in this home. If you read, I believe I put in my brief the argument that runs from several pages before this comment, and then the paragraph immediately after where he says, it might even be the sentence immediately after, it's everywhere. I think maybe it wasn't a great example that he gave about possession, but he does read the instruction when he's talking about possession, and he talks about what was in the house. And I think his point was that in context, based on the evidence that the drugs were everywhere, the defendant was aware that the drugs were in his possession, because I believe his defense was that he didn't know about any of this. He wasn't there. That was defendant's position. So for the misstatements, it's our position, if you read them in context, while maybe it wasn't an artful example or hypothetical using a remote, I believe, or it's our position that he was asking the jury to look in context of everything that was there.
Wasn't his defense that not just he wasn't there, but somebody had a party while he wasn't there without his knowledge?
Right.
And so that would provide, we're talking about overwhelming circumstantial evidence from which the jury could draw an inference. And so he had an explanation for the pervasive presence of drugs. So why doesn't that make the analogy that turns it from an inference into a certainty a little more compelling in this case?
I think part of the problem with that was there was other evidence that while he said there was a party there and he was unaware of it, I believe there had been a detective sitting on the house, and defendant's car had never, or truck had never left the house, even though defendant said, I just got home moments before you came in to do the search warrant. So I believe you look at that in addition to all of the evidence which the prosecutor was trying to tie together to show possession, and that essentially discounts what defendant was saying, and shows that he was there. This was his house, and these drugs are literally everywhere, and the pictures will show that. So on that point, we don't feel that that's a misstatement. We feel it was an artful statement, but not a misstatement, and especially when you do look at everything and that the prosecutor correctly directed the jury to the instruction for possession.
But the problem is not, here's what the judge is going to tell you the black letter law is. The problem is that the prosecutor's taking that and applying it to a factual situation for the jury and saying, you know, this is how you take this language and you apply it to the facts. So I don't see how the instruction cures it after the prosecutor said, here's how you apply that black letter law.
Well, I
Just
think,
the fact that they get to read the instruction doesn't cure the fact that the prosecutors told them how to apply that instruction.
I think you have to look at the fact that this is one sentence at the conclusion of pages of discussion about what possession is. I believe the discussion of possession starts at page 124 and continues for 4 pages. And I think that's why you can't just divorce that example from everything he said about possession. I would agree. Could it have been said better? Yes.
Well, Counselor, it was an incorrect statement. I understand your argument and appreciate that, but it was an incorrect statement about possession, about what makes somebody possessing something in our laws.
Well,
Because not implied, it expressed that he didn't have to know it was there, he didn't have to know it was brought in, it was just a remote there on the couch that somebody brought in, but it's still his.
And I understand that position, and I think with that, you have to look at the following sentences. I believe you can't just take this one sentence out of that paragraph. And he goes on, after talking about the remote, he says, and this is marijuana in his suitcase. There's a tag for it. It's in his bedroom. It's in his toilet. It's in his freezer. It is everywhere. So I think that example with the following sentences, he's trying to tell them that there was an intent, there was knowledge, and because of the prevalence and the apparentness of the drugs. That's why I say you can't divorce that one sentence from the entirety of the paragraph.
Let's talk about the credibility comments.
Yes.
Those are, to me, those are the most troubling because if we all acknowledge that the prosecutor is not entitled to comment on credibility, and I think we all pretty much have to acknowledge that at this point, saying, I believe da-da-da-da-da, and you should also believe da-da-da-da is pretty unequivocally a comment on credibility. You're nodding, so I assume you kind of agree with me, at least as to those isolated statements. That is probably the most well-established rule among all of the rules that one can distill from the last 15 years of Kansas cases on this topic. So why doesn't that reach the level of gross and flagrant or ill will here? Because it's not ambiguous. I mean, those are statements. This is what I believe. And then on top of it, and you should also believe it. I mean, it even goes a step beyond what we normally see. It just seems to me that even a younger and inexperienced prosecutor would have to be aware of the law on that subject, the abundant law from our, abundance is my big word today, I guess. The repeated statements from this court on that kind of comment.
I would agree that it is very clear from this court that you don't comment on the credibility. You don't put forth your opinion to the jury. Did he say I? Yes. And again, it's our position that while he used the term I, and I don't believe that's credible, we don't believe that you can divorce that I from the context of the full statement. Does it give me pause when I see that? Absolutely. But again, I would ask you to look at the entire paragraph where this is taken from, preceding paragraph, and then there's a following paragraph. And he talks about, and even pages before that, I think starting at 129, he is going through the defendant's testimony and the evidence, and he's discussing the conflicting testimony of the defendants and the officers, and even tells the jury it is their job to assess the credibility of the witnesses, and then makes a misstep by using the term I. Again, could he have said it better? Absolutely. But when you take it in context, he was saying that the facts of the case did not support that defendant's story was credible.
He does. It's more than just, we a lot of times see that occasional slip where he says, I don't think you should. And it's clearly or not even clearly, but it's more excusable. But in this case, he's talking about, speaking of the defendant, I don't think he approves of this, I don't think that. And then after placing into context the I with, that's what Mr. Pribble says, he says, I don't believe that's credible. And I don't believe you, ladies and gentlemen, should believe that's credible either. That's taking it beyond what we normally see with these kind of inclusion of the I word, for lack of a better way to put it. But he really does place his assessment of it. I don't think it's credible, and you, ladies and gentlemen, shouldn't believe it's credible either. That's pretty strong.
It is strong, and I would say it's quite possible. Did he get caught up in his discussion of the summation of the conflicting testimony? It's quite possible, but I don't believe, and the state doesn't believe, that this was, as defense wants this court to find, that this was done with any sort of ill will, or if this court determines that this is error, that this was done with any sort of ill will or disregard. And I think, again, if you look at it in context, I think that's what helps you see that this is not ill will. It was a discussion about the evidence and the conflicting testimony between defendant and the officers and the evidence that was there. And so that is our position on these statements regarding credibility. As a part of that issue, they also raised the comment about, in rebuttal, though it doesn't show in their brief that it's during rebuttal, but it is about 15 pages later in rebuttal, he makes the comment, "Do not go down these rabbit holes, do not chase these red herrings." And that is our position is not error. That was a concluding remark after discussing the evidence supporting the charges. It is not tied into, as it appears in defendant's brief, it is not tied into the I statements of "I don't believe" and don't find him credible. Those are completely later, part of his summation, and I believe towards maybe the last or the second to last paragraph of the state's rebuttal close. So those should not be tied together. Finally, the comments regarding shifting the burden of proof. It is our position that those were clearly made in response to defense counsel's argument that the state didn't present testimony from Terry, Alex. We don't know their side of the story. The state did not say that defendant had to call those witnesses. The prosecutor only indicated that defendant had the same ability as the state to subpoena witnesses for trial. And it is our position that this is similar to Virgin Deputy, and that this was a comment in response to defense counsel's argument for favorable inference from the fact that the state did not call witnesses, and was within the wide latitude. This argument was within the wide latitude given to prosecutors to respond to such an inference. This was not. This was an argument that the prosecutor could make, and there's nothing in that paragraph that indicates it was prosecutor's intent to argue that the defendant should have called those witnesses. He was simply saying that he had the same power that the state had. Should you find, as I said before, any of these comments or statements were error, it is our position, again, this was not gross and flagrant. It did not show ill will. The comments here were not repeated, deliberate, calculated, or indifferent to any court ruling. There was no objection. While I understand that doesn't matter, and this can be brought, I think it is still important to consider that of all the individuals in the courtroom, no one jumped up and said, "Whoa, you can't do that." And the prosecutor here did give a correct recitation of the applicable law during his closing. He also indicated that it was the jury's duty to determine the weight and credibility given to each witness's testimony, and he very clearly stated that the burden was on the state to prove defendant guilty. Briefly, if you like, I can touch on I'm out of time, but I can touch on the multiplicity argument if you would like.
Before you do that, counsel, I wanted to stick with the allegation of prosecutorial misconduct. And our case law has indicated that one indicator of ill will or conduct being gross and flagrant is that if the judge has told you through an order in limine or something else during trial not to do something, and the prosecutor repeats the problem. Is there a school of thought that says the same analogy can be raised when prosecutors have been told for at least 20 years not to comment on a witness's credibility, but they do it anyway?
I would say that in this situation, this is limited to that one comment. It is not throughout the entirety of the prosecutor's closing and rebuttal. It would be our position that it is not in blatant disregard to this court's previous rulings. I believe it's our position that this is a situation where the prosecutor was arguing, he was passionate about his case, and instead of saying it's the state's position, he made the misstep of saying I. And it's our position that this isn't an indication on his part of ill will or any desire or intent, conspiracy to shift or lessen the burden on the state, which is very clear from the fact that he makes it clear to the jury that it is his burden and that he does have to prove the case beyond a reasonable doubt.
I was referring more particularly to the comment about I believe.
And I understand, I guess I wasn't clear. It's our position that in this case, we don't think that he was disregarding this court's previous orders. While yes, he uses the term I, and I cannot, it's very clear he uses the term I, but again, I think as part of your review of it, you need to look in context of the entirety of his closing. And this is not a situation where throughout the 20-some pages of direct close is he saying, you need to do this, I believe. Then I think we would be in a different position, that it was a blatant disregard of your previous cases. But here, it's our position we don't have that.
So there would have been a bigger problem if he had said, I don't believe that's credible, and then there was an objection, and the judge said, counsel, don't talk about your belief or credibility of the witnesses, and then he persisted. That would be a much bigger issue in your view.
Yes.
But without that here, it's not a problem.
Is it concerning? Yes. But again, it's our position that in the context, and because there is no objection and no one indicates a problem with that, and it is one isolated paragraph out of many pages, a rather lengthy close, discussing all of the evidence and the testimony, it's our position that it doesn't rise to the level of misconduct.
All right, thank you.
He had one other statement that would indicate that he had superior knowledge. When he said, I know the law enforcement officers didn't make the defendant wear the t-shirt. That suggests that, hey, I know credibility, I know, what the law enforcement officers did. And isn't that the culprit here that we're trying to avoid is unsworn testimony presented to the jury here? I'm telling you how things are.
I would respectfully disagree with that, because I believe it's our position, what he was doing there is he was, his comment was regarding the evidence and the testimony from the officers, that while I think defendant's testimony was that the officers made him put that shirt on, the officers testified that they did not make him put that shirt on, and it was on when they came in.
I understand, and if the argument had been the evidence here should convince you that they didn't do that, but I thought he said, I know the law enforcement officers didn't make him wear the t-shirt, which is in the same vein, in my view, as I believe the credibility, and I know this to be a fact.
His actual statement is, I don't think those things add up, because we know that the officers didn't make him put that shirt on. We know the officers didn't tell him it had smallpox. They didn't say, hey, put this on, let's go out and get a picture. So that comment is directly reflecting the testimony of the officers, and that they testified that they did not make him put on this t-shirt that he complains about.
Okay, thank you.
Mm-hmm.
Did you want to quickly address multiplicity?
I will, if there are any questions regarding the multiplicity argument. I think we cover it fairly well in the brief. It is our position that this this is different conduct. You have possession, no tax stamp marijuana, and no tax stamp methamphetamine. And for marijuana, you have to have a tax stamp, I believe it's 28 grams. So for the state to prove, we had to prove possession of marijuana, at least 28 grams of marijuana with no tax stamp affixed. For methamphetamine, we had to prove possession of at least 1 gram of methamphetamine with no tax stamp affixed. Those are 2 separate crimes with separate elements. And would we have a problem if we had charged, I believe he has over 800 grams, maybe up to 1,600 grams of marijuana, if we had charged 1,600 counts, or, break it down 800, or however the denomination of a tax stamp is issued, if we had charged it that way, yes, I would admit that would be a problem. But because here we have...
why is that?
I believe that's because you have the same exact, it's the same marijuana.
So you're saying that based on the first prong, not the second prong of the analysis. It's the same conduct, or I mean,
I think it could cover both prongs. Actually, I mean, you would have it's the same marijuana that you're cutting into, different weights or different counts for these tax stamps.
what if you had methamphetamine and cocaine?
Because the statute refers to it doesn't refer to it as methamphetamine, it refers to it as controlled substances. I believe that could be a problem. I think that the definition or the statute, because it lines out marijuana, controlled substances, and then there's a third that I think is dosage units. Because it divides those out, I believe that's what needs to be looked at, and why this is okay.
What if you have a controlled substance that's packaged in a dosage unit? If that's possible. I honestly don't know if it is. But just to understand just to try to understand what your argument is.
I guess that if you charge no tax stamp controlled substance under the 1 gram, and then the statute says there are 10 or more dosage units of any controlled substance which is not sold by weight, you could have an issue. But I didn't, since that wasn't present here, I didn't think about that as much. I think it's fairly important here that he had quantity of marijuana and quantity of methamphetamine, and there were no tax stamps on either the marijuana or the methamphetamine, and we had to prove that. Each count, the instruction indicates you have to prove it's marijuana, you possess more than 28 grams, and there's no tax stamp affixed. For methamphetamine, it's more than 1 gram, and no tax stamp affixed. So it's our position here that because of that, these 2 counts are not multiplicious and don't arise from the same conduct.
Can I have one?
Certainly.
The statute, KSA 65-4105, does include marijuana as a controlled substance, though.
Well, I'd have to admit I did not look at that, and I looked at what we had charged under, and the statutes that we charged under.
It excludes it out, what you're talking about, but there's another statute that indicates that it is a Schedule I controlled substance.
I would say that because the statutes that are specific to no tax stamp specify marijuana, controlled substance, and then dosage units, I believe it's our position that would trump that because the statute is very specific as to what you need to show for each substance.
Any further questions?
Yeah, I wanted to clarify, part of your argument at least is that possessing marijuana and, say, possessing cocaine are not, is not unitary conduct, even though they may be at the same time, the same place, same.
That's our
Other-
initial argument, yes, that you possess two separate drugs, so it's not unitary. If there are no other questions, we would simply ask that you affirm the Court of Appeals and the District Court and affirm these convictions.
Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
Unless there are questions, I don't have anything to add for the court.
I did have a question. You've laid out some instances of alleged prosecutorial misconduct. In your view, which is the most damaging to your client?
In this case, I'd say it's kind of a toss-up between the prosecutor commenting on the credibility of my client's testimony and the analogy, because I think those go to the very heart of my client's defense, and they have the most impact on what my client was trying to show the jury in this case. He testified that he didn't know the drugs were there. The analogy essentially says, doesn't matter. And then the state goes on to tell the jury he's not credible. I don't believe that's credible. So I think those are particularly damaging to my client. Which one is worse? I don't know. I think they're both very damaging to my client because they go to the heart of his defense.
Very well, thank you. Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.